Hi, everybody. This is Steve Maggi of SMA Law Firm. Have the pleasure of having with me today on our Building the Bridge episode, Chris Cavaliere, who's a partner at Shoemaker Law Firm in Tampa, Florida, and is specialized in employment law, which is an extremely complex uh, area to practice in. Thanks for being with us, Chris.
Thanks for having me, Steve.
So I want to know more about misclassification. For a lot of our foreign clients, they don't understand what that means. There's this concept of, black or white. Is it an independent contractor? Is it a full-time employee? What happens and what are the risks and potential liabilities of misclassifying an employee?
Sure. Thanks, Steve. So in another video, we talked about what are the differences between independent contractors and employees, and how do you go about classifying one way or another, right? Now it's a great time to talk about, well, what are some of the consequences of getting it wrong? And to be frank, there are several different ways that this can go wrong. There are many different, what I'll call, buckets of liability. If I misclassify a worker, meaning I call a worker an independent contractor, and it's determined that actually that person was really an employee, there are many ways that employer can get penalized for that. There are many different ways that there's liability for misclassification. The first big one is in what I'll call the pay bucket, right? Okay. So as you know, as a lawyer yourself, and I'm sure most companies know this too, you got to pay employees who are not exempt overtime, right? Under the Fair Labor Standards Act. That's the federal law that says you got to pay your non-exempt employees minimum wage and overtime.
Right.
This is one way that it can go wrong for a company. If I misclassify my worker as an independent contractor, and that worker is working over 40 hours every week, and I'm not paying that worker time and a half for overtime, if it's determined that I got that classification wrong, then a court or an agency can say, guess what? Surprise, you actually owe this person back wages in overtime, plus liquidated damages in the same amount, and potentially also attorney's fees.
Oh, wow. Okay.
So this is a big area, probably one of the most common ways that this can go wrong. And it can actually go very wrong depending on how many hours this person is working on a regular basis, right? Same thing with employment benefits, insurance, 401k, retirement. If the worker was misclassified and it was actually the case that they should have been classified as an employee, they're going to be entitled to get those benefits that they should have gotten in the first place. So I'll call that the pay bucket or the benefits bucket.
Okay.
Then there's the disability leave bucket or the general employment law bucket, right? So what am I talking about here? A worker gets hurt or gets sick and asks for leave from the company, and the company says no. This can go wrong, right? If it's determined that the worker was actually an employee all along and not an independent contractor, right, well, then the company might have been required to give them FMLA leave, or the company might have been required to give them some type of reasonable accommodation under the Americans with Disabilities Act, the ADA. There are also immigration issues that can come up. This is in your world, Steve.
Obviously, yeah.
Yeah, an I-9, that the I-9 process applies to employees, not independent contractors. So if you misclassified somebody and you didn't do the I-9 process for them, that could be another area right there. Then there's the insurance world, workers' compensation premiums and unemployment compensation premiums. This is a form of insurance premium that all employers have to pay for their employees. If you've misclassified a worker, you haven't been doing that. There could be penalties for not having done that. Taxes, IRS liability, right? If you've classified a worker as an independent contractor, you have probably not been withholding taxes from their paychecks. You have probably not been paying the employer share of FICA, right? Social Security, Medicare contributions, and there could be back penalties for doing that. And they can be pretty stiff.
Of course. And the tendency, and correct me if I'm wrong, but I've seen this with my European clients, especially, where there's a strong movement towards independent contractors to the point where they have their own, organizations and unions that represent them and give them the benefits. the trend is, and maybe it's a misnomer, but that it's cheaper to do business with independent contractors because you wash your hands of all those responsibilities, right? But there's a certain line here, if I'm understanding correctly, that if you cross it, brings them really into the employee realm, and that's when all these things would apply to you, but also you have to pay the price for having misclassified them in the first place, right?
Absolutely. It's very tempting on the part of companies to, of course, want to classify all of their workers as 1099 independent contractors. Right. But the point I think you and I discussed in the other video about classification issues is that just because the company and the worker agree amongst themselves that they're cool with the independent contractor classification, that is not the end of the story. You can even have a worker sign an independent contractor agreement, and most courts and most agencies will look behind it and say, that's cool that you have that agreement, but let's actually look at this employment relationship to see, let's look under the hood and let's see, does this company have a lot of control over this worker?
Right.
Are they providing benefits? Are they providing insurance? Are they providing the equipment and the materials needed for the job, right? And the more that you say yes to these questions, the more likely it is that despite the fact that you've got an agreement, and despite the fact that you have two grown people agreeing to the relationship, right now, it does not matter.
It almost feels like the employer is assumed to have breached the confidence of the contractor employee. In other words, if they are making an effort and the employee just says, I'm going to sign what you want me to sign, or the independent contractor says, I'm going to sign what you want to sign. In these cases, when it's then reviewed by other bodies or courts, the employer really is kind of the guilty one until proven innocent. Is that right?
I would agree with the sentiment. I think, the idea behind this is that you're typically not having an arm's length transaction. This is not my argument. I'm saying I think this is the rationale behind why there's so much suspicion around just the fact that the worker might have agreed to the classification, is that the feeling is that this is not an arm's length transaction. If you bring on a worker, they're going to sign pretty much anything that you put in front of them. So we're not going to put a whole lot of stock into the fact that there's an agreement. We are going to look at it as a factor, but it tends to be a very, very insignificant factor when compared with all of those other ones that we went into in the other video.
Do you recommend that if potential employees also talk with an employment attorney then to review these contracts and these situations to make sure they're protecting themselves?
Of course. I represent employers in my practice, right? So I'm on the management or the employer side. Mm-hmm. But I'll tell you, especially depending on the significance of the job, right? Especially when you're at the executive level, it becomes all the more important for that employee to have an attorney help them out and just to make sure that everything is on the up and up. Absolutely, there are times when that makes sense.
Okay. Do you have any other tidbits for us, or a take-home lesson for employers to minimize their liabilities?
Yeah, I think one important thing to remember is that these things tend to have a cascading effect. I brought up that workers' comp example before, where this is often the times where this issue is first spotted. It starts in a very innocuous way, right? Worker files a workers' comp claim, it gets denied. Worker says, well, actually, I was an employee. If the agency determines that there's been a misclassification, the government tends to speak with each other, right? Mm-hmm. Agencies tend to communicate.
Okay.
And the agency in charge of workers' compensation claims might tell the Department of Labor, hey, you might want to look into the pay practices here. You might want to look into the overtime issues here because we think that this company's been misclassifying their workers.
Oh, wow. So
it tends to have a cascading effect.
So all the more exponential. If it becomes something that's seen as, system-wide or firm-wide, then the consequences could be catastrophic, is what you're saying.
They can, and always good to remind everybody listening that that some states have their own rules on independent contractor classifications, California specifically, and I've of course been focusing on federal and Florida law.
Yeah, we see it in immigration with Department of Labor, how if there's systemic abuse of the immigration system in terms of how you're classifying your workers or what you're paying them, or if they're working on site or off site, the DOL can get involved as well, and that can lead to major fines. So it's obviously, this is true on all levels, state and federal levels.
It is, absolutely.
Chris, thank you so much for all your knowledge and your time today. How do people get in touch with you? An employer wants to really think, forward-thinking employer wants to minimize risk, potential liabilities, do things the right way. How do they get in touch with you?
Absolutely. So you can call me at my direct line, 813-676-7208, or you can email me at cavaliere@shoemaker.com.
Fantastic. Thanks so much, Chris.
Thank you, Steve.